Article 142, Prof, is very clear in the establishment of tribunals. And it says, Chairman, with your leave, Article 142.1 says, there shall be established in each region of Ghana such regional tribunals as the Chief Justice may determine. Now, the Courts Act, 1993, variously amended in 202 and 203, actually imported Article 142 into the Courts Act and actually added more in terms of the creation of the regional tribunals. So when the impression is created that you are going to create these court systems, I got confused. So I want to find out from you, are you going to rather implement the law, asking that regional tribunals be established, shall be established, or is going to be your creature by policy? Chairman, thank you.
Mr. Chair, on a point of order, he said that the Courts Act.
You don't have the floor.
He says.
You do not have the floor. Even at point of order, I need to give you the floor. Honorable nominee, may you proceed to answer the question.
Well, I agree with my former student that I taught him well. He's drawn a distinction that I glossed over. The tribunals are actually established by the Constitution under Article 142. Now, the Courts Act was variously amended, and sorry, Mr. Chairman, but I don't have the amendments here, but I do remember vaguely there was an attempt to delete provisions relating to the tribunals by the VCRAC committee. So if you take the compendium, the green compendium, I think that was where it was done. And the idea was to take them out, in terms of the statutory implementation. So what I would do, if Parliament gives me the nod, is to overhaul the law relating to the public tribunals by bringing a new bill that I will introduce rapidly, because the president has hit the road running, and we, his nominees and his appointees, are his, supplementary wheels. We have to help him, to run as fast as possible. So I will bring a bill that will comprehensively deal with the implementation of the letter and spirit of Article 142 of the Constitution. Thank you very much, Mr. Chairman.
Thank you very much. Yes, you want a point of order. Is the point of order relating to the answer or the question being asked?
Mr. Chair, both. It made reference
but
to an
amendment. Under the rules, you cannot take a point of order on a question being asked.
Mr. Chair, on the answer. On the answer.
Now, tell me what exactly is the answer that you are taking the point of order on?
Mr.
And
Chair,
what is your point of order?
Very respectfully. The Courts Amendment Act of 2002 amended the Courts Act of 1993 to abolish the district and community tribunals. So the only tribunal which remains on our statute book is the regional tribunal, which the Constitutional Review, government has accepted the Constitutional Review Committee's report to abolish. So that is the only tribunal which is on our statute book.
So how different is that from the answer provided by the nominee, that he doesn't have the Court Act here, but he believes of an attempt to take it off from the Court Act? So it's not different.
Mr. Chair, very respectfully, this is a committee of record, so it is important that records are set so that listeners will know that it doesn't exist anymore.
Then pose a question is John Dako.
Thank you, Mr. Chairman. Honorable nominee, I'm sure you are aware of a company called Cassius Mining. That company obtained a grant of prospecting license from the Minister for Lands and Natural Resources sometime in 2016. Actually, 14 days after the Mahama administration had lost power. The company at the time did not comply with the prospecting license. And they had made an application for renewal of the prospecting license. Following that, Honorable nominee, you became the counsel for
Honourable Member,
Cassius Mining.
do you have the evidence that the company did not comply? And in any case, that particular company is not before us. So you know the rules relating to speaking about persons who are not before us and will not have the opportunity to defend themselves. So be guided.
Thank you, Mr. Chairman. So following that, Mr. Nominee, you became the counsel for Cassius Mining and made demands on the government for renewal of the company's prospecting license. In fact, Mr. Nominee, you, as a lawyer for the company, you wrote a letter dated 21st February 2020, attention the Chief Executive Officer of Minerals Commission. You stated variously, but in particular, clause 4 of your letter to the Chief Executive of Minerals Commission, you stated that the fact that the two shareholders of the company prior convictions cannot vitiate the license, it is not a relevant consideration. You stated, Mr. Nominee, that it is spurious and disingenuous for you to suggest that the minister can, on this basis, refuse to grant the license renewal. But even if it were so, damages will still flow and the government of Ghana will remain liable. Mr. Nominee, it will interest you to know that about 2 weeks ago, this company, Cassius Mining, for which you were once their legal counsel, has filed an arbitration against the government of Ghana, claiming in excess of $440 million United States dollars